The committee will come to order if everyone could take their seats. Mr. Doggett is recognized for 5 minutes.
Thank you, Mr. Chairman. What happened here is outrageous and inexcusable, and unless those of us who strongly disagree with the Tea Party on many issues defend it from any impairment and allow it to be as wrong as it wants to be, we impair our democracy. Mr. George, many charges have been made here this morning. You, as Inspector General under Title V, Section 2, have a statutory responsibility as Inspector General to prevent and detect fraud and abuse in the programs and operations of the IRS, do you not?
That is correct, sir.
And as best I can determine, sir, you have fulfilled that responsibility faithfully and forthrightly. Let me ask you if, using the extensive audit and investigation powers you have as Inspector General, you have found any evidence of corruption at the IRS?
No, not at this time, sir.
Yes, sir. And let me ask you, sir, with your extensive powers, if you have found that our tax system is rotten at the core?
No, definitely not rotten at the core, sir.
Yes, sir. And let me ask you, sir, if you have, using your statutory powers and fulfilling your responsibility, determined that the IRS picks who wins and who loses in America?
I don't believe that is the case.
No, sir. You have not. And the statements that were made in very inflammatory charges at the beginning of this hearing, it is obvious, have no basis in fact, at least any fact that has yet been demonstrated this morning. It is important that in addressing and fully correcting one wrong, we not complete and be involved in other wrongs, such as encouraging the proliferation of secret corporate money, not just the proliferation and pollution of our democracy by that money, but that it be tax subsidized secret corporate money. That we not permit those who have a fundamental disagreement with the progressive tax system using this incident as a basis for shifting even more of the burden of financing our defense and our essential government services onto working people. That we not permit those who have an agenda that has now been voted 37 times to try to undermine the full and effective implementation of the Affordable Health Care Act so that the health care crisis is ended for families across this country. That's what's at stake here. That's what's been discussed here. It is not based on any fact associated with this investigation to this date, as indicated by the Republican-appointed Inspector General whose job it was to determine whether any of these charges had merit. Now, let me move to an area where I disagree with some of my Democratic colleagues in their comments this morning. I don't believe there's any lack of clarity in the statute here. The statute that is in effect has been in effect for decades, and it requires that before there is tax-exempt status, as Mr. Lawrence O'Donnell, as the crew group, the Citizens for Responsibility and Ethics in Washington has pointed out in a petition, you are to be denied this status if you are not exclusively engaged in social welfare according to the statute. Is that not correct? The statute is explicit. It uses the words exclusively. The regulation the IRS adopted 30 or 40 years ago uses different language.
If this is addressed to me,
yes, sir.
Mr. Doggett, I have to demur the Secretary. That's a tax policy question, and I'm not in a position.
I'm not asking you for tax policy. I'm just asking for a clear reading of the statute, and a clear reading of the statute that has been in place for decades and is in place today says that there should be a denial of tax-exempt status to any group that is not exclusively engaged in social welfare operations. And it was only after a regulation adopted long ago, long before any of you were at the IRS, that changed exclusively to primarily, that there was even any discretion for this section to be involved in this operation.
Mr. Doggett, I do know that we have indicated that some clarification from those in the policy area of the Department of the Treasury might be needed in this area to help clarify again.
Well, in April, Citizens for Responsibility and Ethics in Washington filed a petition with the Treasury Department and the IRS to address that. If the statute, the clear wording of the statute had been followed, we would not be having to deal today with selective enforcement. We wouldn't have any problems with enforcement in this area at all. And I hope that that petition is honored and responded to promptly, as I believe you have fulfilled your responsibilities, Mr. George, as Inspector General. Thank you for your testimony, and Mr. Miller, thank you for yours and for stepping aside.
Thank you. Time has expired. Mr. Roscom is recognized.
Thank you, Mr. Chairman. Mr. Miller, you may object to the word targeting, but it's used in the IG report 16 times. So it's a common understanding of the word, and so I would just suggest that it's a well-settled doctrine and we not waste a lot of time parsing on it. You admit that you spoke with Ms. Lerner and Celia Rudy about the planted question beforehand. Can you tell us more about that conversation?
I did not speak to Celia Rodi, and I believe I did talk to Lois about the possibility of, now that the TIGTA report was finalized, now that we knew all the facts, now that we had responded in writing and everything was done, did it make sense for us to start talking about this in public?
Can you walk me through the logic that animated in your mind at that time where you thought it would be a good idea to make a public disclosure to the American Bar Association rather than coming and following up on your duty to disclose that to the House?
So we were going to do it at the same time, I believe. Our intent was to talk to you all at the same time.
But that didn't happen, did it?
It did not happen, I don't believe.
What other recollection do you have, or what other experience did you have when you were talking with Ms. Lerner about this scheme to have the planted question at the ABA?
I'm not sure what you're asking, sir.
I'm asking, what's your recollection of that conversation?
We talked about what would be said and how we might do it.
Where did the conversation take place?
I believe it was over the phone.
What day did the conversation take place?
I'd have to look back at my notes on that, sir.
You've got notes on that?
I'd have to try to find them. I'm not.
Why did you say you had notes if you don't think you have notes?
Sir, please.
Wait.
I don't.
Please. Do you have notes or don't you have notes?
I don't know.
Okay. Let's shift gears. A little while ago, you were being you engaged with Mr. Reichert on the question as to whether you knew that this committee, this whole idea of does the committee have the right to know this information, and then you sort of sheltered yourself in this idea of, well, I've always told the truth. Let's set that aside for a moment. Now, you're a lawyer and I'm a lawyer. You know that in the process of discovery, Mr. Miller, that when you find subsequent information, counsel has a duty to disclose that to the opposite party. There's no Perry Mason moments. There's no gotcha moments. There's no litigious situation where somebody comes in and says, oh, we are just showing up, Your Honor, with this information and we haven't disclosed it to the other side. Don't you acknowledge that you had a duty based on your testimony before this committee of what your actual knowledge was? Didn't you have a duty, Mr. Miller, to come forward and disclose that to the committee based on all this cascading inquiries that had happened from the Ways and Means Committee directed to you?
So I don't believe so, sir. What was happening was I was in possession of some facts, was not possession of all facts. We had done an internal review to see what we needed to do to get these cases moving because, again, the processing was bad, the listing was bad. Those are two different pieces we were dealing with. TIGTA was in at exactly the same time. They were getting all the facts. We were going to wait for them to get the facts so that I didn't come in and either mess up their investigation or otherwise give you facts that were not correct, sir.
So you weren't concerned about the timing of the TIGTA investigation when you and Ms. Lerner made the decision to move forward and do the planted question. Is that right?
It was done.
It was done.
We had all the facts, and we had made our written response.
Right, I understand that. So, in other words, you had the actual information, the totality of the information that you're describing today. You had it all in your possession at the time at which you were under a scheme with Ms. Lerner to go and do a planted question. Is that right?
I sort of object to the term scheme. We had the information. We were reaching out to the
committee. An understanding, a written or not written down contemplated
reaching out to the
play,
committee
a
at the same
manipulation, call it what you will. You had all of the information, isn't that right?
We were reaching out to the committee at the same time.
Well, what form did that outreach take?
We called to try to get on the calendar.
You called to try and get on the calendar. Is that all you got?
It's the truth.
Okay. I find it incredibly ironic. On the one hand, you're arguing today that the IRS is not corrupt. But the subtext of that is you're saying, look, we're just incompetent. And I think it is a perilous pathway to go down. There's sort of this notion that hasn't been satisfactorily answered, and that is, if the targeting wasn't based on philosophy, how come only conservatives got snagged?
They didn't, sir. Organizations from all walks and all persuasions were pulled in. That's shown by the fact that only 70 of the 300 organizations were Tea Party organizations of the ones that were looked at by TIGTA.
All right.
But
Time
that
has
testimony is in contradiction to the IG testimony. I yield
All right.
back.
Time has expired. Mr. Thompson's recognized.
Thank you, Mr. Chairman. I appreciate the fact that we're having this hearing and want very much to be able to get to the bottom of this. More important, I want to make sure, or as important, I want to make sure that we are able to do all that we can to prevent it from ever happening again, for all the same reasons that many of my colleagues on both sides of the aisle mentioned today. And I want to associate myself with the outrageous and intolerable group as to where I think this ranks. What I would like to know, General George, first, in your testimony, you had a section that is titled Results of Review, where you say the IRS used inappropriate criteria for identifying these organizations. Is that legal?
Is it legal? It is.
Actually, I'm trying to get a sense of what inappropriate criteria means.
It is not illegal, sir,
Okay.
but it was unusual.
And then you enumerate them. Inappropriate criteria were developed and stayed in place for a total of more than 18 months. Is that illegal?
It is not illegal, but it was inappropriate.
I understand that. I'm just trying to get a sense of.
And sir, if I may, it's contrary to Treasury regulations and other policies then in place by the department.
Understand. The substantial delays, is that illegal or inappropriate?
It's inappropriate.
And then the third, the unnecessary information, illegal or inappropriate?
Inappropriate.
Okay, thank you very much. You also outline recommendations that you think are most critical and explain whether they are, if enacted, they're enough to prevent this from happening again. Are they?
The vast majority are, and the IRS agreed to the vast majority of them.
And do you have some mechanism, some matrix for making sure that they are put in place? And is there a plan to go back and review these and to continue your good work of review to ensure that your recommendations are being followed out? And that your recommendations are enough to protect the citizens of our great country?
Mr. Thompson, you anticipated almost our entire future plan. We are both going to take a look to see whether the IRS has successfully implemented. As you believe you indicated, or someone did, the president indicated that he was going to ensure that the IRS complies with those recommendations, and it would definitely be our intention to follow up to guarantee that that has occurred.
One of the responsibilities that we have is also an oversight responsibility. Is there something in your recommendations and in your subsequent plans that will keep us in that loop? Or are we going to have to find out about this outrageous and intolerable behavior through some other means?
Mr. Thompson, we publish an audit plan each year laying out which audits that we're going to engage in. We request information or solicit ideas from Congress, from the administration, and from anyone who has a tangible role in the system of tax administration. And it is our intention to once again do that, and there's no doubt in my mind that we will follow up with Congress on this matter on a regular basis.
Thank you. Mr. Miller, what are your obligations in regard to reporting this type of behavior to Congress?
I'd have to go back and take a look. I don't believe there's an obligation. What happened here, sir, is we knew TIGTA was in. I knew TIGTA was in May, almost immediately, when we were involved. We had a meeting with Mr. George and company in May where there's an indication they'd be done this summer. Our understanding is they were going to get the facts, they were going to get them out there. There was never the intention or belief that these facts would not come out in full.
General George, is there a need to pass specific legislation that would make it more difficult or hopefully impossible for this to happen again, and to strengthen the requirements for reporting when something this outrageous and intolerable takes place?
Mr. Thompson, I will answer your question in full, but I have to again preface that the Secretary has delegated tax policy questions to the Assistant Secretary.
That's not, it's a
All right.
process question, not
No.
But time has expired, so you can supplement that answer in writing if you wish. Mr. Gerlach is recognized for 5 minutes.
Thank you, Mr. Chairman. According to the Inspector General's report, the IRS started its inappropriate handling of certain tax-exempt organization applications in early 2010. And to swing back to some of the prior testimony, Mr. Miller, you indicated that you never spoke, or excuse me, before I ask that question, let me highlight two pieces of media articles that appeared, also one in 2010 as well as one more recently. In September 2010, there was an article in the Weekly Standard concerning the concerns of the Coke industry's attorney that there had been confidential taxpayer information potentially in the hands of senior administration officials that were part of an August 27, 2010 on-the-record background briefing. Subsequently, just a few days ago, there in the USA Today was a column, an op-ed by a gentleman connected with the National Organization of Marriage, who indicates in that op-ed that the release of this organization's confidential tax return to the Human Rights Campaign is a canary in the coal mine of IRS corruption, contrary to assertions that the targeting of Tea Party groups was an error in judgment by low-level IRS bureaucrats. The release of this confidential data to a group of this nature suggests the possibility of complicity at the highest levels of politics and government. So back to the questions of whether there was any information sharing of taxpayer records, taxpayer returns with anybody outside of the IRS. Mr. Miller, you indicated in testimony some moments ago that you never spoke personally or communicated personally with anyone in the White House about the sharing of confidential taxpayer information. Is that correct?
I believe so.
Do you have any reason to believe that at some point you did, from, say, January 2010, speak to somebody in the White House or communicate in another way with somebody in the White House about the sharing of confidential taxpayer information?
I don't think that would happen.
So your answer is no, you did not?
I don't believe I did.
Are you aware of any other IRS official from that time period to present that communicated with anybody in the White House concerning the sharing of confidential taxpayer information to somebody outside of the IRS?
So may I ask, can I ask, are you asking whether...
I'm asking whether you're aware of anybody else in the IRS that ever from January 2010 to present communicated or spoke with anybody in the White House about the sharing of confidential taxpayer information?
So I don't believe so, but what I'm confused about, sir, I apologize, but just so I'm clear of what I'm answering. Are you talking about whether I believe we shared information?
Whether you have information or belief that any confidential taxpayer information, taxpayer being individuals, being organizations, being businesses,
Was shared.
all of that information being shared with somebody outside of the IRS in violation of Section 6103.
I have no knowledge of that.
You have no knowledge of that.
That's a question I understand. Thank you, sir.
You did indicate previously, however, in questioning, that you did speak yourself with Treasury Department officials regarding the sharing of information. I'm not saying the White House now, I'm saying the Treasury Department. If I wrote that correctly, you did speak to somebody in Treasury about that at some point. Is that correct?
I don't think so. I mean, but again, let's be clear.
Did you ever speak, I'll ask the question more clearly and more directly.
Did I ever
Did
share
you ever speak
taxpayer
or
information?
communicate with anybody in Treasury Department who was not within the IRS about the sharing of confidential taxpayer information in violation of 6103?
Can I rephrase it and you tell me what?
No,
right.
I phrased the
I don't
question,
know, I don't
you
know what you're
phrased the
asking.
answers.
If you're asking me whether did I ever share 6103?
I didn't ask that. Did you ever communicate or speak with anybody in the Treasury Department not within the IRS about the sharing of confidential information, taxpayer information?
So I don't believe so, but if I don't know whether you're talking about the subject, which would be absolutely fine to talk to them about, or the
That's what I'm trying to inquire about, Mr. Miller. I'm trying to find out what you did, what you knew, and when you knew that, and who you spoke with. So you're saying today that at no time from January 2010 to present did you speak to somebody in the Treasury Department about the sharing of confidential taxpayer information?
No, what I'm saying, sir, is the following. I have
No, I'd like an answer to my question,
taxpayer
sir.
Information.
Did you ever do that?
Did I ever talk to them about the sharing of?
Talk or communicate? It might have been by email, might have been by fax, might have been...
I don't believe so.
By
but
sign
again,
language.
I can tell you categorically I never shared information. Did I ever talk to them about the rules around it? I don't think so, but that would be permissible.
Well, were you aware, I think you, to Chairman Camp's questions, you were aware of news reporting about the National Organization of Marriage and the concern they had about the sharing of their confidential information. You indicated on the record that you were aware of that news story. So on that story, any other story, did you talk or communicate with anybody outside of the IRS in Treasury about that issue?
I don't know. I don't believe so, though.
Okay, will you check all of your records, all of your notes, all of your emails to get back to this committee about whether your answer is different than what you're providing right now?
Yeah, but what I can say again is
Well, I have a limited
that
time.
All right. Time is expiring, has expired at this point. So why don't we move on to Mr. Kind?
Thank you, Mr. Chairman, and thank you, gentlemen, for your testimony here today. I think it's been illuminating and very helpful. Mr. Miller, let me start with you. I assume you agree with the premise that if there is a agency in the federal government that just needs to be above reproach, and no hint of bias, partisanship, ill treatment, mistreatment, unequal treatment to any individual or any organization, it is the IRS. Is that right?
I agree, sir, and that's what's sad about this.
And obviously the optics of what happened there in the Cincinnati office and reviewing the applications, this is what comes from it. Is that right?
The perception is bad.
It's my understanding, too, that based on the Inspector General's report and the recommendations, the IRS has taken that up and is trying to do their best to implement that to ensure that this does not happen in the future again.
We will implement all recommendations, and it will not happen again.
Mr. Neal asked you previously in his line of questioning about the accountability, who's being held accountable and why, and that obviously you've rendered your resignation to the President, and he's accepted that as Commissioner of IRS. Is that right?
I have done so to the Secretary.
Okay. And any other instances of accountability as far as those at the Cincinnati office, those in charge of the Cincinnati office and the development and the use of this criteria?
So I think I mentioned that there were two instances in which there was counseling suggested and there was a reassignment of someone. But what I should say, and what I said in my opening statement, is we now have possession of the facts with respect to the TIGTA report. Now is the time we should be looking at that.
Is there
Once we have the facts.
any pushback from the IRS with the Inspector General's report and some of the recommendations that they're making? Any difference of opinion?
There's no error between us on the recommendations.
Okay. Is there a role for the Congress to be working with the IRS to ensure that something like this does not happen in the future? I'm thinking specifically of Post Citizens United and 70,000 applications that was submitted. And a doubling, I understand, of C4 applications too. Do you feel there's sufficient personnel in order to expedite the review of these applications?
There are not sufficient personnel.
Of course, I don't think we'll have many recommendations on the other side as far as allocating more resources to the IRS so you're sufficiently staffed in order to deal with the huge influx of applications that the IRS is experiencing right now. I think there is a role for the Congress, and we've got to share some responsibility as well. But, Mr. George, let me ask you, I think part of the problem is the definition of the criteria of primarily engaged in social welfare seems to be an inherently subjective criteria with no clear, bright lines or clear rules. I think the IRS was trying to further define that for the division in Cincinnati, but is there further tightening of that definition which would be helpful to IRS personnel when it comes time to review the applications?
The answer is yes.
Is that something that has to be done internally with IRS, or is there a role for Congress to intervene and try to help further define and present some more objective and bright line rules when it comes to reviewing social welfare applications?
It's my understanding that the IRS has the authority to do this on its own without legislative fixing.
Okay, I think obviously this committee will need to be working with IRS too to ensure that that gets done, because otherwise it's going to be an inherently flawed human process of subjectively applying this criteria, I feel, especially with the huge influx of applications. Now, some of this has been delved into, but I think it's so important that it needs to be reiterated. Mr. George, I apologize if you think you've made yourself clear on it, but according to your report, you found no bias or partisanship behind the development and the use of the criteria for selecting applications from the Cincinnati office. Is that right?
That is correct, sir. But we did find gross mismanagement in the overall.
And that's clear in your report, too. Did you find any evidence that anyone outside of the IRS was involved in the development and the review?
Not at this time, sir.
Not the White House or Treasury?
That's correct, sir.
Thank you. Thank you, Mr. Chairman.
Thank you. I will recognize Dr. Price for 5 minutes.
Thank you, Mr. Chairman. I think if I'm sitting at home trying to figure out what's going on here and listening to the testimony and the remarkable revelation in some of these questions, you get some snickers after some of them, but you have the federal government asking what books you read, have the federal government asking whether or not you know anybody in your organization that's going to run for political office. This is chilling stuff. This is very, very serious. Mr. Miller, do you accept the findings of the IG report?
We do, sir.
One of those findings is that groups were targeted. Do you accept that finding?
I would not characterize it as targeting, but
you can understand why others would believe, including the Inspector General, would believe that groups were targeted.
I think the groups that were put into the centralized grouping would have gone in. They would have gone in whether we had done the correct thing or were we using...
You've described the list of criteria being used to identify these groups as obnoxious, correct?
Correct.
And it's not just Tea Party groups, right? It's not just conservative groups. In fact, there are religious organizations, are there not?
I don't know that, sir.
Are you not aware that there are religious organizations that were identified by the list of criteria that were formulated?
I'm actually unaware that there were, and I say that as though I don't know. I've looked at the list, but very quickly.
Are you aware that there were some Baptist church organizations that were identified for greater scrutiny? And
I was not aware of that, sir.
Who's Sarah Hall Ingram?
She is an executive at the Internal Revenue Service who does the Affordable Care Act work for us.
That's where she works now?
Yes, sir.
Where'd she work during the period of time under question here, 2010 to 2012?
Someone has corrected my prior comment, I think. So 11 and 12, I think she was already working on Affordable Care Act. I don't know when in 10 we made that.
Did she ever hold the title of Director of Tax-exempt organizations for the IRS?
She held the Division Commissioner title.
So she had responsibility over much of the concerns and discussion that we're having today. Is that correct?
At the time, she was Division Commissioner, yes.
So would she have known about this list of criteria that has been formulated, had been formulated?
I have no reason to believe that she would.
That she would?
Yeah. I have no reason to believe that she would. I'm sorry if I wasn't clear. I don't think so.
You don't think she knew about the criteria of the folks under her responsibility?
There were a couple of thousand folks. And
have you ever had that conversation with her?
No.
You've never asked her whether she knew.
So I'm not sure she was in that job at the time, sir.
And you've identified her current position as one with the IRS oversight over the ACA and regulations related to the ACA. Is that correct?
Correct.
Who appointed her?
I moved her into that job.
You've also said that in the context of the criteria list and what we're talking about today, that the IRS, quote, provided horrible service, unquote. Correct?
I think that's correct.
That's what you said earlier today. And the individual who was overseeing a portion of this and had responsibility for the provision of this, quote, horrible service now sits over the entity at the IRS that will determine whether or not people are complying with the rules of the ACA. Is that not correct?
No, I don't think it is, sir.
So Sarah Ingram is not at the IRS over control of the regulatory
She was for
authority of the ACA?
at most a period of this time, but we'd have to go back. I don't think your timeline works perfectly, sir. I'd have to go back and check. There may be a period of time when she was still in that job, but she had transferred
Mr.
over.
McDermott, in questioning you, said the IRS wouldn't have any access to medical records. Is that correct?
I believe that's correct.
So it would be unnecessary for them to gain access to medical records, correct?
I can't.
Be unnecessary?
I think so.
Isn't that how you described the questions and the information that the IRS folks were gaining through the criteria list unnecessary?
I think if you are you talking about the letters?
I'm saying that there is a parallel here in the expansive nature of what the IRS has done. Would you care to recharacterize what the unnecessary word? Is it illegal what they have done?
It is absolutely not illegal.
It's not illegal what the IRS has done.
Here, so let me understand the question. What is your statement as to what is illegal?
Do you believe it is illegal for employees of the IRS to create lists to target individual groups and citizens in this country?
I think the Treasury Inspector General indicated that it might not be, but others will be able to tell that.
What do you believe?
I don't believe it is. I don't believe it should happen.
Thank you, Mr. Chair.
Please don't get me wrong. It should not happen.
Thank you. Mr. Blumenauer is recognized for 5 minutes.
Thank you, Mr. Chairman. And I appreciate the opportunity for our being able to listen to the witnesses and try and develop the record, and people putting forth their own ideas, their own questions, clarification. I think, Mr. Inspector General, that you have provided a tremendous service with the report, straightforward, identifying mismanagement, inappropriate activity, and I hope that people will be able to actually read the report, to reflect on it. I appreciate your being here, Mr. Miller. It's not the most comfortable. I appreciate that you, as a career civil servant, accepted responsibility even though you hadn't done these things directly, and resigned. I mean, it's an air of responsibility you don't often see in the political arena, I will say. But I am hopeful that we can continue to probe, to direct, to make sure that no political entity is subjected to inappropriate activity on behalf of the IRS. I appreciate some of my colleagues talking about efforts that we can do to clarify laws and regulations together to be able to make sure that there is less ambiguity and that there are better standards. But I also think at some point it will be interesting to reflect on Congress's role in what the chairman referred to as, in pretty strong terms, about a tax code. When I came here in the 104th Congress, there were 114,000 employees in the IRS. Since I've been here, Congress, in its wisdom, has expanded the code, made it more complex, and cut dramatically the men and women who are on the front lines to deal with it. Their inadequate training budget. We've had this testimony just across the Capitol before the Senate this last week. And I really hope that there's an opportunity to think about how we support the integrity of the Internal Revenue Service, not just by making sure there isn't inappropriate or gross mismanagement, there is accountability, there is clarification, but we rely on it to be able to function. And Congress has slowly been starving the budget of the IRS at a time when each dollar spent on those employees gives the federal government about $214 in revenue. And for us to not make sure that it's adequately staffed, adequately trained, adequately equipped, invites shortcuts, makes it harder to have the oversight and the accountability, and harder for overall performance. I think it's inexcusable to cross the line. I think it's important that we bear down, we understand, we make sure it doesn't happen again. But I also think as the Congress has made the code more and more complex, given the IRS fewer and fewer resources to administer it, make it difficult to train, I think it undermines the ability to take a complex entity that relies on self-reporting and people having confidence in it. And I'm hopeful that this isn't something that we slide past. I appreciate, Mr. Chairman, your interest in simplifying and reforming the code, but I also hope that we look at the task they've been given, the budget they've been given, and think a little bit about maybe a rate of return that would more than pay for itself if we invested in training, in management, and having more than 150 people to deal with the avalanche of these applications. I guess that wasn't so much a question, but it is something that occurred to me, and I know, Mr. Miller, you had referenced the stress that that group is on and how hard it is to keep track. And at some point, if you would provide to the committee, not putting you on the spot now, but some reflections on what it would take to do this right, I think it would be a valuable part of the committee record going forward, because we all want it to have integrity, we want it done right, we want to treat our employees and the taxpayers properly. Thank you.
Mr. Buchanan's recognized.
Thank you, Mr. Chairman. Mr. Miller, I want to talk a little about the culture of the organization. I was looking at the note, your bio, 90,000 employees, $12 billion budget. You've been there 25 years. I'm concerned, and I guess to start off, we've got a mission statement there. I'm very concerned about the breadth and the depth of maybe what's going on. I think a lot of employees probably do a good job, but I've been a person that's been in business 30 years and run larger organizations. So you've got a mission statement in terms of talking about working for the American people, doing what's right, playing by the rules. Is that something that's internalized at the IRS, or is that just something on a website?
So I believe, Congressman, it's internalized, and the vast majority of our folk are hardworking, incredibly honest people. I'm going to tell you, and you guys should hear that as these discussions occur, it's damaging to the morale of those people. It's probably ultimately damaging to the sense of voluntary compliance, which underlies our entire tax system.
Well, let me just say, I think there's probably a lot of good people, but at the same time, we've got a massive PR problem at minimum.
We do.
And this has got to be dealt with quickly, and it can't just drag on for 6 months to a year. So I think we need to get to the bottom of it. The other thing, let me just ask, in terms of that size organization, who's in charge? Who's the boss? How is that hierarchy? How does it work? I ran a very decentralized business where I had a corporate structure, but I had managers and partners in different operations. How is the IRS, in terms of being an acting commissioner? You've been there 25 years. Who do you report to, or the commissioner ideally in the past? Who do they report to? And at what point, when something like this comes up, who's involved at the next level up?
So the reporting chain in the organization is there are 2 deputies and reporting to the commissioner, and the commissioner reports to the deputy secretary of Treasury.
Who's ultimately responsible?
The commissioner, acting commissioner, not the Treasury. The Treasury relationship is such that they would not be involved.
So who would be responsible for you? Who basically asked you to resign or fired you?
It would be Secretary Liu.
Secretary Treasurer. The other thing is, let me ask you, there's been 2 people that have been, were you terminated or fired? What happened there? Or are you getting ready to retire?
I was asked to resign, and I will retire.
Okay.
As under the civil service rules.
Now, on what basis do you feel like you're getting asked, and maybe one other person, I guess, got asked, but it seems like there's a lot of other people, ideally in Cincinnati and Washington and other parts, that haven't been held accountable?
I'm not sure what the question is, sir. If I could answer it, and then tell me if I'm answering the wrong question.
Okay, go ahead.
We're not done yet. We're not. We now have the Treasury Inspector General's report. We now have the sense of the facts. Now is the time for those that remain, including the incoming acting commissioner, Mr. Werfel, to take those actions.
Let me mention this. It's been brought up with a couple of the ladies that work with you, Lois Lehner and Sarah Ingram. What's being done about those 2? Because they've been in the press. There's a lot of concern about that. They ran a large operation, and it seems to be at the heart of the issues today. I think that's got to get dealt with in a very aggressive, clear way in the next week or 2.
I don't know whether it will be or not. That will be up to the new acting commissioner.
And let me just ask you, in terms of the new acting commissioner, are we looking to get a permanent commissioner, or is this going to be, for a period of time?
I don't have that information. I would assume, however, that we ought to have a nomination. And
I hope, because I think at the end of the day that leadership matters, and getting the right culture, the right environment within the organization, the IRS, it needs incredible leadership and incredible integrity. And we need to make sure that that person, not so much the acting one, but the permanent one, is the right person going forward. I yield back.
I very much agree, sir.
Ms. Schwartz is recognized for 5 minutes.
Thank you, and I appreciate the opportunity to ask a question. Let me just say a couple things and then ask a question, and I will attempt to be brief. This is not easy hearing for you or for us. We are outraged on behalf of the American people. That's number one. The American people, deserve to be able to trust their government for fairness and lack of bias, and that was violated. And that violation is outrageous and unacceptable to us, and I hope to you. And the fact that number 2, there need to be changes. It's already happening, some changes you're making, but we need to be assured that those changes will be made. Things happen, investigations have to be done, and then changes have to be made to assure the American people that we know that and we will not accept bias or discrimination in any way. I think that is clear to all of us. The second thing I will say is that this committee and Congress also has a responsibility to do this in our own questioning and our own demand for accountability and transparency from you, from the administration, from anything that happened, to do it in a way that is not political either. And I think we have to be very careful about that, and I would compel all of my colleagues to make sure that we also engage in this in a way that is clear and fair and non-political. This is we all agree that something has to be done. We should do it. So my question, though, is really about sort of more broadly what's going on in the divisions that handle the applications for nonprofit status. I have heard in my own office that groups come to us that have applied for nonprofit status, mostly 501c3, not C4, which was the issue here. But the backlog of a year, they don't understand why it takes so long. They don't understand why they are not clear about what's wrong with their application. They're not hearing back. And given some of the cuts that we've made, nonprofit groups in particular, the ones that are not the 501c3 in particular, but really are looking to try and make up some of the gaps that are here, to be able to raise money and charitable contributions and to make a difference in our communities. And I, for one, need to have better clarification about what the criteria is, why don't they hear back, why those applications are taking longer than a year, if there are problems with them, what kind of questions you legitimately can ask and ones you can't, and how we can move this process forward. And I think that we have every reason to ask those questions and to get that kind of answers on behalf of our constituents. And then again, it goes for all of the nonprofit organizations. If there are reasons to review an application in greater depth, and there may well be, certainly we have to understand that better, and so do the people making those applications. They should not be in the dark about the criteria. They should not be in the dark about why it's sitting on somebody's desk or receiving more review. So if you could clarify for us now, Mr. Miller, or give us some more information as we go forward about what that criteria is and what we can expect and what we can explain and how we can help you make sure that you are doing this right. And when they mess up, Mr. George, you're in there and doing that investigation and getting those answers and correcting those, and we can assure the American people of the right process, the fairness of that process, the criteria that's being used, and a timely, appropriate, responsive process to American taxpayers and certainly to hopeful nonprofit organizations. So if we have a chance to answer that, I would appreciate it.
And I think probably it's a big enough question that will follow up in writing. But the process right now is as I've mentioned, we have a limited number of people, 140 to 200, that work on the 70,000 applications that come in for tax-exempt status. Most of those are 501c3 organizations. Now, 501c3 organizations get a number of tax benefits. They get deductibility of contributions. They get the ability in some instances to issue bonds. They get state tax exemptions, property tax exemptions, postal rate reductions. There are significant benefits in addition to just tax exemption, and we have to look at them. We do. And many of them are small organizations that should go through very quickly, and some of them are large organizations that we need to take a look at. The largest hospital systems, the largest universities, there are some large organizations. Then you look at particular issues within them. And we will look for, is there enormment? Is there private benefit? Is there political activity going on? Because again, C3s, no political activity is permissible. C4s, some, but not a primary amount of activities can be political in nature. Those are things that take time. We try to move them along as fast as we can. We do not have enough people right now.
Yeah. So do you feel like you don't have enough staff, but you're clear about the criteria and that criteria?
I'm afraid time has expired, so you'll have to respond.
This will be a continuing conversation. Yes. Thank you.
Mr. Smith is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Miller, could you define political activity as it would relate to the agency and the applications?
Under the Internal Revenue Code, political campaign activity has some definitional limits. You need a candidate. You need a candidate for public office. And that's sort of what you need for it to be a political campaign activity under 501c3 and 501c4. A little different under 527 rules.
And was it the concern about political activity that led to the centralization, organization of reviewing the applications?
I believe it was. It was the fact that we were seeing more applications indicating that they might be doing political activity, and it's an area that is very difficult for us. Is it education? Is it an issue ad? Is it actual campaign intervention? Those are very difficult for us to parse out. The decision was made to try to get them into one group and educate those people. How they started that process was one of the problems here. The other problem here, as I've mentioned, is the method of processing these cases was flawed. And I think that the TIGTA report and Mr. Russell's report goes into great detail on the problems that we saw in terms of the lack of communication between pieces of the service, the letters that were going out that were overly broad, and the complaints that we were getting rightfully from those who were given a remarkably little amount of time to explain an awful lot of stuff.
And how many employees at the IRS would you say